This is ArtSense, a podcast focused on educating and informing listeners about the past, present, and future of art. I'm Craig Gould. On today's episode, I have a conversation about copyright law's impact on the evolving art world with a legal luminary, Dale Sandali. Dale is a nationally recognized leader in the field of intellectual property litigation, having successfully litigated and tried numerous high-profile cases, as well as having argued before the U.S. Supreme Court. She's a 2023 inductee into the IP Hall of Fame. In 2016, Law 360 named Dale one of the 25 icons of IP who have, quote, made an indelible mark in the IP area. Managing Intellectual Property selected Dale as one of the 6, quote, outstanding IP practitioners in the United States, and named her trial victory for J.K. Rowling on the high-profile Lexicon Fair Use case as the Copyright Trial of the Year. Dale has also served as the Vice Chair of the Copyright Division and Chair of the IP Special Issues Division for the IP section of the American Bar Association, and currently serves on counsel for the ABA IP section. In addition to her active law practice, Dale also teaches courses on copyright and trademark litigation at Harvard Law School. In the conversation, we explore the basic precepts of copyright law, define the key terms, discuss the effects of the Warhol versus Goldsmith case, and look at the legal challenges at play with the emergence of artificial intelligence. And now, a conversation about copyright law in the art world with IP legal expert Dale Sandali. Dale Sandali, thank you so much for joining me this week on the ArtSense podcast. Dale, you're a partner in Kirkland & Ellis's New York office and chair of Kirkland's Copyright, Trademark, Internet, and Advertising Practice Group. You've litigated some very high-profile cases in regards to copyright and fair use, including J.K. Rowling's Lexicon case, Shepard Fairey's Hope poster. It's not an exaggeration to say that you're one of the top IP and copyright lawyers in the U.S., and I wanted to have you on the broadcast to talk about the changing landscape of copyright law and fair use as it pertains to us in the art world. Maybe we could start with kind of a basic overview of what protections the Copyright Act provides. In particular, how would you currently define the term fair use?
Fair enough. Thank you for that intro as well. So copyright comes right out of the United States Constitution, as does patent law, and it's intended to give authors of works, creative people who come up with new things and add value to the world by so doing it, an exclusive right to get the value of their work for a limited period of time. And that means not just the value of the specific, say, book they wrote, but also the value of things that are based on said book called derivative works. And it's not just the right to reproduce a work, because you think of copyright, you think of copying, but you also have the rights as the copyright owner to decide how your work will be displayed, or whether the work can be imported, or how the work can be distributed. So the bottom line is, if you are the copyright owner, you have a broad swath of rights to be able to incentivize you to continue to create new works. Now, the second part of your question is, what's fair use and how does that relate to it? Well, fair use is also in the copyright law. It's part of what we call in the United States the Copyright Statute of 1976. And what this does is it balances out a little bit all those big rights that I told you that the copyright owner has, because it provides a defense to copyright infringement for somebody who wants to make use of a copyright owner's work. And we call that fair use. And the concept is, if it's fair use, then it's not a copyright infringement. And so what happened was initially over centuries, this had been in what we call the common law, just court cases have talked about this. But then when it came to the time for 1976, Congress, in enacting the new statute, put down a specific provision of the copyright statute that deals with fair use. And what it says is, and we copyright lawyers always talk about it as the 4 fair use factors, is that lays out that there is 4 non-exclusive factors, which means it could be other things too, but at least these 4 that courts have to consider in deciding whether something is fair use. The first factor is the purpose and character of the use. What are you using it for? The second is the nature of the copyrighted work. If it's something like a super creative Harry Potter book, that's going to be entitled under the case law to more protection to maybe a functional work, like certain parts of certain computer programs. The third factor deals with the amount and substantiality of what you took from the copyright owner. And this is looked at from both the quantitative point of view, how many lines, how much code, how much of the photograph, the artwork, but also from a qualitative point of view. Are you taking the most important part? Are you taking what we call the heart of the work? And that's the third factor. And then finally, the fourth factor looks to the effect on the market of the copyrighted work. In other words, if the defendant, who's often not always the defendant, sometimes someone can start a lawsuit even if they and become the plaintiff if they've been accused of copyright infringement. We call that a declaratory judgment action. But in any case, the thought is that the how much has the second user's conduct hurt the market, the value, the for the copyright owner's work. And this is looked at not just for that work itself, but any likely derivative markets that might be developed over time, like, I don't know, a book version of the movie, for example, or a movie version of a book. And courts look at this from the perspective of, if the use became widespread and everybody and his brother were doing it, would that harm the copyright owner in some foreseeable way? And what courts do then, and what lawyers do to try to help courts, is they march through these factors and try to explain the situation to the court and sometimes to the jury. And ultimately, at the end of the day, the court will decide whether something is fair use or not.
So the wording in the act as handed down by Congress hasn't changed, but it seems that, with, the Andy Warhol Foundation versus Lynn Goldsmith decision from the Supreme Court, maybe I can get your opinion on whether or not it's setting a precedent for a far narrower definition of that fair use. What are we seeing as the effects, or do we anticipate any effects from this particular case?
Well, I can give you a definitive. It's too early to tell, but there's a divided point of view, with just like there was a divided point of view as to how the case should come out. There's a divided point of view as to what the import of the case would be. A lot of people, and I think I'm probably one of them, are more of the view that this is that the Warhol v. Goldsmith decision was not a departure from existing case law, and certainly not from the statute, but more was a clarification of what the law had always been. And what we tend to do as copyright lawyers is, you see law advancing and changing over time, and new cases present new issues. And we sometimes talk about it as the fair use pendulum. And sometimes the pendulum swings towards fair use, and sometimes the pendulum swings back against fair use. And a lot of people in the field were of the view that, in particular, I'm sure it's a case you are familiar with, the Carew versus Richard Prince case involving the Rastafarian book that was used by Prince. Was images were ripped out of the book to make, in some cases, collages, in some cases, other types of works by Prince. And that was deemed to be a transformative use by the Second Circuit some years ago. That was a very controversial decision, which led to even the Second Circuit to say, in subsequent cases, that maybe that's the high watermark of first use. Maybe the pendulum's really swung out there and we need to course correct. Other circuits, another art case, the Scani Nation case, which involved using a photograph but altering it in a way to make a political commentary about the subject of that photograph, also said, I'm not sure if Carew got it right. It seems to be straying more and more from those four factors to place too much emphasis on transformativeness. So what I'm trying to tell you is that before you even got to the Warhol v. Goldsmith case, there was already a sign in the case law of concern about what transformativeness meant and whether it was becoming too much of a litmus test. Like if it was transformative, that's all it mattered, and you didn't need to look at whether the work was commercial or how much was taken or what kind of work it was or what the effect on the market was. As long as it was deemed transformative, that was the get out of jail free card. And there seemed to be increasing pushback to that, especially, remember, one of your first questions was, well, what rights do you have as a copyright owner? And one of those rights is the right to make derivative works. So if you make a beautiful painting, you have the right to make it into note cards. You have the right to put it on your website. You have the right to make it into a t-shirt. All those kinds of things are what you would have as a derivative work right. And so the concern started to develop in case law that how do you draw the line between a derivative work, which is based on a work, which is the right of the copyright owner, and something that's transformative, that's fair use, that isn't something that the first author, the first copyright owner has the ability to control. So what I'm trying to say is that while there's a lot of focus and attention now on fair use as a result of the Warhol versus Goldsmith case and other cases, I don't think it's really changed the law so much as provided some clarification as to the process you should go through in examining these factors under the statute and figuring out whether something is or isn't fair use.
Say I'm a figurative artist and I'm working from reference material that is beyond what I'm capable of taking on my own, right? And I am looking at combining, disassembling, putting back together. How can I have assurance that I'm creating what in my mind may be something that's transformative? How can I guarantee that I'm working within my rights and I'm working in good faith with where I got these images that I'm transforming? Like, how can I assure that I'm not going to run into a legal problem? Is it a matter of trying to arrange some sort of licensing deal up front, or is there some sort of quick litmus test that I can use to look at my work and say, that's a problem or that's not?
That's a really good question. And one of the reasons that I did this area of law is, my background is in the arts and theater and fine arts. My sister's an artist, and I care a lot about artists and artists not being ripped off, and artists who usually don't go to law school, though some of them do, how they're going to have certainty. And the benefit or the burden, the good and bad thing about fair use law is it's super flexible. I will tell you that there are other countries that either don't have fair use law at all. So if you use somebody else's work, you're just out of luck, or they have a statute that specifically says it's okay to use it for news reporting or something like that. But unless you fit into that specific pigeonhole, you're out of luck. So those things, not having fair use law, sometimes it's called fair dealing abroad, or having a statute that's super specific, you could do this, meaning you can't do anything else, that would provide more clarity. But you could argue as an artist that, you know what, I might prefer a little more flexibility, which is what US law does, even at the expense of a little clarity. So what does that mean as a practical basis? That's one of the reasons I wanted to try to do this talk with you is obviously the easiest thing is, sure, do everything yourself from scratch to the extent there is a from scratch. That's not always a feasible thing to do. And I'm certainly aware of artists who say, well, how am I going to have access to photos and people and things that I need to get pictures of? All right. Another option, and you alluded to that yourself, and that was a big part of the Warhol v. Goldsmith case, would be, if in doubt, to attempt to get a license. There's plenty of places out there. The AP has a licensing archive. Getty has a licensing archive. There's many, many more places than that are smaller shops that offer licenses. And one of the things, because I know that, some people said, oh, that, that's scary and that's expensive. And, we all know that any kind of cost can be hard for some folks to pay. And I'm not minimizing that. But if you read the Supreme Court's decision itself in the Warhol v. Goldsmith, the original license fee that Goldsmith charged and received for use of the photograph of Prince as an artist reference for that initial Vanity Fair cover was $400. Now, again, that could be a lot of money for somebody, and I'm not downplaying that, but that was $400 for a pretty prominent use on a cover, right? And so that could be a way of buying certainty. What else can you do? Well, one of the other things, again, assuming most artists are on both sides, right? Most artists want to protect their own work, but they also want some flexibility as to how they create their work. So you have to think about it. I often say to people, how would you feel if the situation was reversed? Would you feel that your ox was being gored, that you were being taken advantage of? That might give you a sense of how likely you might be to get a claim about something. But part of the reason I went over those 4 fair use factors is to think about, and it's hard for an artist to be a lawyer. No one's asking you to be a lawyer, but the idea that everyone can go afford lawyers isn't that easy either, although many law schools have things like the Volunteer Lawyers for the Arts, which are pro bono things to provide assistance to artists who are below a certain level of income to get free help. Columbia has one at New York City, but many, many other cities and states have them too. You can do a internet search for Volunteer Lawyers for the Arts, and that could connect you. But think about what you're doing. Under the Supreme Court's decision in Warhol v. Goldsmith, you need to, as the second artist, justify why you should be able to use the first artist's work without compensation. Now, there may be stronger things to justify that use than others. If you are doing something that's a parody of the first work, if you are doing something that's a political statement that is using the first work as part of that political statement, in other words, not just using it as I would argue Shepard Fairey did. He wasn't commenting on that photograph. He was using it for a different, for the poster that he did. He wasn't, saying that there was anything wrong with the photo or critiquing the photo. But if you're using something and critiquing something for a political purpose, like the Scotty Nation case, that could be more helpful. But if what you're really doing at its heart is using something for an artist reference, that's a very recognizable artist reference, which is what the Supreme Court said happened in Worrell v. Goldsmith, that might be something that courts would say there's a traditional market for artist references. There's a benefit to people from encouraging photographers or others to come up with these references to begin with. And we want to encourage that so that those first works are created in the first place, so those second creators can make use of them. So my answer to your question is yes, try to do it yourself, hard. Get a license, not as hard as you think, or as costly. Or third, either with the assistance of a lawyer or on your own, be thinking about what your justification is. And if it's more of a literal artist reference, that's higher risk than if you were using something to report on the news or comment on some important thing about society.
I've traded some emails with an artist named Ryan Montgomery, and he was the subject of an ArtNet News article about a confrontation that he had with Lynn Goldsmith in the aftermath of these proceedings, because he had made a work referencing that Prince image as part of a political statement about the findings of kind of a commentary on the trial. And Lynn Goldsmith asked him to take the image down off of social media. His larger practice is around political statements regarding, like, for example, the Supreme Court, and using images of the justices and commenting on them. He can't take images of Supreme Court justices, especially in the court. Is he working within a realm where he can lean on the political statement side of it? Or is he, again, someone that should be thinking about licensing up front?
Well, the first answer to that question comes right from the majority opinion that Justice Sotomayor wrote for the Supreme Court, and that is context is everything, and the specific facts are everything. And I know that's not that helpful necessarily. I am going to try to generalize, but this is where I would say, I'm an IP lawyer, so part of what I also do is trademark law. Is disclaimer. I'm not giving legal advice, and I don't know enough about facts. It's garbage in, garbage out exactly about Mr. Montgomery or his art. But to the extent that part of his art is about using images of justices or other people to make commentary about their decisions or something like that, that is, first, from a right of publicity point of view, these would be public figures, which would often be a good thing to weigh in favor of someone wishing to comment. And there's the part of remember I went over those 4 factors in the copyright statute? Well, part of those 4 factors come right after what we call is the preamble, the beginning part of those 4 factors. And that says that the types of uses that would be fair use or might be fair use are things like, quote, criticism, commentary, news reporting, teaching, scholarship, or research. Now, that's not an exclusive list. It could be some other things, but it helps to let people, the Supreme Court said, think about that, because that's what Congress had in mind. So therefore, if Mr. Montgomery or somebody else was doing things in the nature of criticism or commentary, that's more likely to be fair use and is more likely to protect that type of use. There can be some nuances, though, again, similar to the Shepard-Fairey case, in the sense of, while the ultimate message might be commentary, is there commentary about the original photograph or book that was taken? Or was it just simply used to make a parody or a statement about something else, where using the original material wasn't for the purpose of commenting on that original material. The more you comment on the original material, the more you can see there could be a justification for that purpose. And I can explain that in a minute. The other type of thing that you told me about that Mr. Montgomery did is it sounds like he did some of his own artwork, again using the same Prince photograph of Prince that Goldsmith had made, and he did his own non-Andy Warhol version of it, and in his mind that was sounded like he was helping to illustrate some of his thoughts about the decision.
Right.
And depending on how you look at that, again, no one knows the full context, the full story from a post, but it looked a lot like, again, use of the original photograph that Goldsmith worked so hard to protect, to be made into a painting form. And where was it as a commentary on her original photograph? Not clear that there was any. And at least the Supreme Court, she just spent years trying to win this case before the Supreme Court. I guess she took the position that would not have been fair use. I'm not aware of any lawsuit being filed. I'm not aware of any of this being other than an exchange of emails and discussion in the blogosphere. But to the extent that things are done for commentary, then you're in a better place than if they aren't. Can I give you a couple of examples to maybe illustrate this?
Absolutely.
All right. Well, these were slightly I'm talking about a slightly older case, but one that I think helps illustrate this point, because you may remember back in the day, there was a pretty funny advertisement for a movie. I think it was Naked Gun 2.5, something like that. But it starred Leslie Nielsen,
right,
and it showed a picture of him basically naked in the same pose, looking like he was pregnant, as the famous Demi Moore, Annie Leibovitz photograph. And the court found that was fair use. Now, this was an ad for a movie, right? So that was very commercial, right? But just because it was commercial didn't mean that it wasn't fair use. And it was fair use because it wasn't that they just took some random picture of Leslie Nielsen and put it on the movie poster. If that were done, maybe that would just be an artist reference, or maybe just a direct use of some nice, attractive photograph of Leslie Nielsen. And maybe that wouldn't be fair use. That would just be taking a photograph of an attractive Leslie Nielsen and using it for a movie poster. Hey, you should pay for that use, a lot of law would say. But because this use was instead deemed a send up, a critique, a making fun of the Annie Leibovitz photograph, because it was saying, hey, that photograph's a little precious, a little special, a little perfect. And now I'm going to make fun of that precious moment by having Leslie Nielsen in this comedy movie kind of doing it. And so that's why the court said, this is a parody. You can do this. You're commenting on the Leibovitz photograph, and that's therefore a type of fair use. And I'm trying to say that's a different kind of thing than if it were a different kind of picture of Leslie Nielsen and it was just used. And I think that was the distinction in Warhol versus Goldsmith that the Supreme Court was getting at. The Supreme Court didn't, at least in the majority opinion, so however attractive Warhol painting was, it used that photograph as its base, as its reference, and it wasn't doing anything to critique or comment on or make fun of or anything like that. It was just used as an artist reference, similar to the $400 version that had been or the one that had been licensed back in the day. So that's what I'm trying to do. So with the hope of maybe being helpful to artists in letting them think about, are you using something more as an artist reference, kind of a literal thing that people often would license for, or are you taking that original thing, commenting on it, and using it for a different purpose than the original. Um, a lot of what the Supreme Court's opinion talks about is, does the second use substitute for the first use? And if it substitutes for the first use, then that's not likely to be fair use.
So, is there any consideration to an artist using it for a one of one original artwork that's only going to be displayed in one space on one wall versus a piece of artwork that's intended to be reproduced, made in editions, or sold as an illustration for mass media? Is the story any different if it's just one painting that's going to be on one person's wall? Is there any sort of claim of, like, it's my First Amendment right of free self-expression to make this one thing versus it becoming something that seems more published? Is there any delineation there?
Yes, I think there is, and it comes up in a couple of ways. The way that the law works, the Supreme Court could only make a binding decision about the specific Warhol use of the specific Goldsmith photograph and issue. But in talking about that and what we call dicta, in other words, non-binding reasoning of the court said you have to look at each specific use. And the court said, well, if something was in they said a not-for-profit museum, or if something was an individual type of a one-off work as opposed to something that would be more likely to be mass produced. And there's other cases that have talked about that kind of thing too. You can see how the court might feel that the purpose and character is different and less likely to substitute for the original work with regard to factor one, and two, that there may be less harm under factor four, right? If something is only a one-off thing that's for a artistic purpose. And the court also said that if someone were doing a book about Warhol and wanted to show this photograph to illustrate and talk about Warhol's, life and work, the court didn't say it was fair use. The court flagged that might be different too. So in general, the Supreme Court said you do look at the justification, what the purpose was of the second artist, and you look at also whether how commercial was it. The court recognized that all of this is a question of degree, that nowadays virtually everything can be commercial, often to some degree, but you look at, how commercial the use is, how important the purpose is, how distinct the purpose is from the original, such that it might be more or less substitutive under factor one. And then you look at factor four and you think about, is this really going to hurt someone or not in their business and make it hard for them to make a living selling their photographs or whatever it is? So the bottom line is, yes, an artist who is just doing a one-off work for a book or for a museum likely to have a better argument than one who is not. But let's also remember, let's say that museum paid $100 million, I'm making it up, for that painting.
Right.
A court might still find that to be a very commercial use that normally should have an artist reference fee paid. We don't know. That question wasn't before the court, but that's certainly a possibility.
In the past, there have been a number of artists that have blatantly appropriated art as part of their artistic practice. And so I'm thinking in terms of like Sherry Levine photographing a Walker Evans photograph and basically titling it after Walker Evans. And of course, there are still cases in the court right now pending with Richard Prince. And those cases where it's kind of pure appropriation, what defense do artists like that have as a photographer photographing a photograph and saying, this is my statement on the originality of artwork or, my homage to this artist? In some of these cases, is it a matter of it wouldn't pass the test, but nobody has chosen to litigate?
Well, you don't know whether it would or wouldn't have passed the test, and the tests do evolve over time because precedent changes or evolves over time. So you don't know whether people thought that Sherry Levine's work was infringing or wasn't infringing or what they thought about it. But what you can look at it from the perspective of what we know today. Let's pretending like she was creating the after Walker Evans today works. And it's interesting because one of the things that she did is she said after Walker Evans, she didn't try to pass off the works as just Sherry Levine, right? She noted the credit. And I argued this Daystar case before the United States Supreme Court, which basically said artistic credit isn't something that we're going to credit under the Lanham Act. That kind of principle is part of is more likely to adhere to outside the United States. You might have heard about moral rights of artists and things like that. But it was interesting to me, knowing the Daystar case, that Justice Sotomayor, in the majority opinion, in talking about the facts of the Goldsmith case, frequently pointed out that there was a lack of credit to Goldsmith by Warhol or the Warhol Foundation or Vanity Fair, Condé Nast in the use. I just put a pin in that because a lot of artists do care about credit and a lot of people care about credit and who things are from. So I just think about that. But and I don't profess to be an expert on Sherry Levine, but I know that she overtly said that she was engaging in commentary. She was talking about a lot of her work. I think it was, at least some commentators refer to it as the feminist hijacking of patriarchal authority. And she was making you see these images in a new light. And if I were Sherry Levine, I would try to argue that that was a justification for her kind of use that was different from what you would have if you were merely taking something as an artist reference, as a way of avoiding the drudgery of coming up with something on your own. I don't know whether it would fly or not, but certainly she has an argument that she is using it for this purpose of commentary, that objectively someone would see that and understand it and understand how those works were created. Now, Richard Prince is more complicated, right? Because as we started off, he won that Carrier case. And the thing about that Carrier case, and to some degree, the Warhol recent case, we'll see if courts say how much it's overruled or not. Carrier, I'm not going to come to an opinion on that at the moment, but the Carrier case focused a lot on how much a work had been changed. The court found that some of the works that Prince made that were more like collages were more transformative than ones where just a guitar was painted on or added, and that was not clear whether that was transformative. And what's interesting about the Supreme Court opinion, among other things, in Warhol, is that it made clear that how much you changed it wasn't the litmus test. You have to look at what the purpose is. And it may be that if you only used a foot and you ended up with a Niagara-like work by Koons or something like that, that purpose and justification, you were only using a little bit of it, you were using it in connection with lots of other things, it wasn't recognizable. Maybe the Supreme Court would say that was okay, maybe not. But the point is just purely how much you changed it, or how, or as people would argue that you argued new meaning or message, wasn't enough. But for Prince, after he won that case, I'm certainly not his psychiatrist, but he seems to have doubled down on fair use, right? I mean, famously, he took Instagram and other postings of art, and he just blew that up and sold it for, at least it's been reported, for something like 100,000 per work or something like that. And the only thing he did is sort of have very small text at the bottom of some of these images that were hard to understand what they were. And that led to a couple of lawsuits, both of which have gotten past the motion to dismiss stage, where courts have said, maybe this isn't fair use. Maybe you are taking too much of the original, causing these personal harm, and maybe you should be sharing some of this $100,000. We don't know what the ultimate effect of this decision is going to be on those cases, because they'll have to present the evidence fully to the court if they're not settled, and we shall see. But I do think that type of work, where the burden will be on, the burden is always on the person claiming fair use. It's an affirmative defense. The burden is not on the copyright owner to disprove fair use. It's the burden on the person using the first author's work to prove that it is fair use. And I think that for that type of literal, recognizable use, and I'll add in uncredited use perhaps too, the people may have to work a little harder to explain their justification.
I'd like to change gears for just a second and talk a little bit about artificial intelligence, because the use of AI for the creation of images is based on the use of trained data sets of images. And it appears that these data sets of images are being scraped without the permission of some artists, photographers, licensing companies. I know there's even a suit out there by Getty Images right now against an AI company. I know that I've seen some people create work that they say this is my AI creation, but it's obviously a derivative work of another artist who they trained their set on. And I'm just wondering, what do you think the law is going to say about artificial intelligence utilizing artist work as input for creating work that in some cases may not show any similarities, but in other cases it's a perfectly recognizable style? How is artificial intelligence changing this landscape?
Well, first off, is a lot of this debate's reminded me of when the internet became popular or domain names became popular. It's like, oh my God, what law is going to apply here? What do we do? And what usually happens is courts say, well, we apply the existing copyright law to the new fact pattern and see what that means. And there have been some cases filed. I'm litigating some cases, though not in the art space on it, as others are too. But what I think you need to look at it, courts are going to look at it, as the Warhol case made clear, from a fact-specific point of view. And one thing will be looking at the ingestion, the use of, we're talking about visual art now, visual art as training data. And there are many who believe that that is a type of use that should be licensed, and that there's a market for licensing artwork, and that it is some people will say that's per se uh, a copyright infringement. Others would say you can never say per se copyright infringement. You need to look at the specific uses and decide whether that's infringement. So what I'm trying to say is that on the ingestion side, the argument would be that copying the works to begin with, scraping it, would be infringement, is what some would be arguing. The second stage of it, though, is, well, what about the output? As you were saying, we call it substantially similar. If at the end of the day, you can still make out who that superhero is, or what that painting is that's not in the public domain, or something like that, is that an infringement? Well, the first step is a court would first look to see if it is substantially similar, right? Just because something may have a similar style doesn't mean that it's substantially similar under copyright law, because you're not supposed to own a style. It's like you're not supposed to own an idea. But let's just say that anyone and his brother would say this looks like the same thing from an objective type of test. Then there could be a claim for copyright infringement. And the interesting thing would be, who would it be against? Would it be against the person who used the tool to create that output? Would it be against the company who set it up so that it could be used to be that way? Would it be against all those people? Some of the original cases that have been filed are suing everybody that they can think of, to try to cast a wide net. And I think that over time, there will be more cases that will decide the issue of both the input and the output. But you raise another question, though, because I know that your podcast has lots of artists. And I know that there are artists, friends of mine, including, who like to use things like Midjourney or other forms of AI product out there to create work. And the law is trying to figure out what to do about that, because the Copyright Office has decided, and it started originally, or was recognized a few years ago, what we call the monkey selfie case, that a monkey couldn't own, or a gorilla couldn't own, a copyright. Only humans can own copyrights. And then that kind of thing was applied to AI to say, if ultimately the artist, the creator, is a computer, nobody can own that. That's a computer. What happened was a graphic novel artist got a copyright registration for her graphic novel Zaraya of the Dawn, and then proudly said, and this was all done by Midjourney and was done by AI. And then the Copyright Office initiated a cancellation proceeding to take the copyright away, because it wasn't done by a person, but was done, according to the author herself, by the AI. But the question may be, and I don't know how these cases are going to come out, but you could look at it a lot of different ways, depending on exactly how the work was created, right? Like, who did the lion's share of the work? In other words, we all accept, I think, that you could use Photoshop to create artwork, right? And it's not unusual to have technological tools to create art. And will the AI be seen as a tool, like another kind of paintbrush, or will it be seen as more of a photocopier? And is it creative if you just type in a sentence about what you want? Is that enough? But suppose you, as some people have said they've spent 80 hours fine-tuning everything exactly so to do X, Y, or Z. And they've created this image to go with that image and this text so that you have a compilation kind of artwork. There's a lot of debate on it. And there are some pre-existing cases not dealing with AI. The Torosoft case is one, and the Reardon case about software and CGI software movies. But the idea is that copyright law recognizes that someone doing the lion's share of a work could be a creator, and that could mean the person who created the software and not necessarily the software. So what I'm trying to say is that yes, everyone right now is very much focused on, is training data infringing and is output infringing, and if so, who's liable? Yes. But then there's this separate issue of things are being generated. Can anyone own the copyright to that? If so, who should own the copyright to it? And what standard should be applied to that? And I think that's going to be interesting to see how it plays out.
Well, what are our key takeaways for artists? If they were the top 2 or 3 things to keep in mind as takeaways, what should they be, Dale?
Well, one thing is that they're concerned about protecting their own work. There's just basic things that they can do for free that they should think about, which is you don't need to file a copyright registration in the United States to have a copyright. You need to have one before you file a lawsuit. But you could just put, like I could, write a book or a fan fiction or whatever and put, or what, maybe not a fan fiction, that would be probably an improper derivative work, but I can create a bad drawing and put on it copyright 2023 Dale Sandali. And you absolutely have the right to do that. And that's free. And by doing that, you are telling the world, I'm claiming this. It's like a beware of dog sign. Don't copy this. I'm trying to protect it. It'll also help people know it's by you because you put your name on it. And if ever that's taken away by somebody, there's something in the Digital Millennium Copyright and the Computer Fraud Abuse Act that say that taking away copyright management information can subject someone to liability, because we want to be able to find authors. So one thing someone can do is just for free put a copyright notice on their work, if not the work itself, but on the website, because you may not want to hurt the image, but somewhere to show that you're claiming copyright. Yes, another thing you can do is you could try to register your copyright. You can do that online. You don't need a lawyer. They walk you through it. It's not that expensive. It varies a little bit, but it's like 40 or 50 bucks. It's not thousands of bucks. And the benefit of doing that is that it lets you potentially, if someone does infringe your work, have a claim for attorney's fees and a claim for damages. There's also something called the Case Act, where people who don't have a lot of money can bring copyright claims. They're capped at how much money they can recover, but it's designed to be a cheap and inexpensive way where you may not even need a lawyer to prosecute your claims. It's called the Case Act, CASE, and they're doing that out of Washington. It's all on the papers. If you're thinking of the flip side and you want to make use of something, then I think we go back to some of the things that I said earlier. Yeah, it's not, maybe the golden rule is too simplistic. Would you be upset if somebody were doing it to you? But it's kind of, in the absence of a lawyer, can be helpful. But is this a traditional thing that artists license, like an artist reference? Or is it not? And are you more critical of the thing that you're taking? Are you making a political statement? What is your justification? If a judge ever asks you, why do you deserve to do this without getting the permission of the copyright owner, what would you say? And what would the impact of that be on that person's livelihood? Those are the questions to think about and to answer.
Well, Dale, it's not an exaggeration to say that this has been one of the most informative episodes of the podcast. And I really appreciate you taking time to talk to my audience of artists and art world professionals about an area that has always been totally murky in my mind. And hopefully we've provided a little bit more clarity today.
I hope so. It's a pleasure. It's a pleasure to talk about these things. And it's also a pleasure to see how much the law actually matters and impacts real people who were trying to do their best to create art. And as a copyright lawyer, that means a lot to me.
That's all the time we have for this week. You've been listening to ArtSense. You can find the show on Apple Podcasts, iTunes, Google Play, Stitcher Radio, Spotify, or your favorite podcast app. If you've enjoyed this podcast, be sure to subscribe. And while you're there, please rate the show and leave a quick review. Your feedback is the key to other folks finding us. And if you'd like to see images related to the conversation, read the transcript, and find other bonus features, you can go to cambia.art and click on the podcast tab. If you'd like to reach out to me, you can email me at craig@cambia.art. Thanks for listening.